For hundreds of thousands of veteran educators across India, a single date became a threat to their livelihoods: August 31st, 2028. By that day, they either passed a mandatory qualification test or they lost their jobs. That deadline was the result of a 2025 Supreme Court ruling in Anjuman Ishat-e-Talim Trust versus State of Maharashtra. In that judgment, the court ruled that the minimum qualifications outlined in the Right to Education Act apply to all in-service teachers, regardless of when they were hired. This meant every primary teacher in the country was now legally required to pass the Teacher Eligibility Test, or TET. The mandate carried a heavy penalty. Any teacher with more than 5 years of remaining service who failed to qualify by the 2028 deadline would face compulsory retirement. The court provided only one narrow exception. Teachers with less than 5 years of service remaining were exempt from termination, but they were declared permanently ineligible for any future promotions. This ruling directly impacted educators who had served for decades in rural areas, teachers hired under valid rules long before the TET was conceptualized. By enforcing these standards retroactively, the judicial interpretation created an immediate threat to the continuity and stability of the entire elementary education system. Parliament responded by introducing Bill No. XXII of 2026, an amendment to the Right to Education Act. Parliament designed this specific bill to function as a statutory bypass, using precise drafting to legally neutralize the Supreme Court's interpretation of teacher qualifications. The bill relies on the doctrine of legitimate expectation, the principle that employees should be protected from sudden, retroactive changes to the rules that governed their initial appointment. We will now deconstruct the 2026 amendment section by section to see how the legislature dismantled the Supreme Court's mandate while staying within constitutional bounds. The conflict centers on Section 23 of the original 2009 RTE Act, which allows the government to set the minimum qualifications for teachers. The Supreme Court interpreted these qualifications as retroactive requirements. From the court's perspective, Article 21A's promise of quality education meant that every teacher, no matter their tenure, had to meet the same modern testing standard. This triggered immediate pushback from states like West Bengal and Uttar Pradesh, who filed review petitions to protect their workforces from mass termination. Some states attempted administrative workarounds. West Bengal's School Education Department tried to reclassify pre-2016 educators into a normal section within their digital portals, attempting to bypass these specific primary or upper primary designations the court's mandate targeted. These bureaucratic maneuvers were ineffective. A Supreme Court mandate based on federal law supersedes state-level portal classifications and department guidelines. Although a May 2026 review hearing extended the compliance deadline to 2028, the court refused to abandon the retroactive requirement itself. Because state-level tweaks failed to provide long-term protection, only an act of Parliament could legally shield these teachers by changing the text of the statute the court was interpreting. The 2026 bill executes this shield by inserting new, highly specific subsections directly into Section 23 of the Principal Act. The new subsection 4 begins with the phrase, "notwithstanding anything contained in this act." This gives the clause overriding authority over any other rules or prior court interpretations. This section explicitly states that no teacher hired before the RTE Act shall be required to acquire new qualifications as a condition for keeping their job, their seniority, or their retirement benefits. Subsection 5 then fixes the timeline for all future requirements. It legally establishes that the TET and any other newly prescribed tests apply strictly prospectively, meaning they only apply to appointments made after the Act commenced. To provide a final layer of protection, the bill adds an entirely new section, Section 23A. Section 23A locks in the promotional avenues and retirement benefits of veteran teachers, stating they cannot be altered to their disadvantage by the introduction of new qualification rules. These drafting choices legally separate veteran teachers from the retroactive application of new educational standards, providing them with a permanent statutory shield. Establishing a prospective timeline was only half the battle. Parliament also had to dismantle the court's specific threat of compulsory retirement. The new Section 23(6)A acts as a protective barrier. It specifically prohibits the state from using a failure to pass the TET as a ground for compulsory retirement, termination, or the denial of promotions for veteran staff. Furthermore, Section 39A gives the government the power to issue protective directions to ensure no teacher hired before the Act faces adverse service consequences. This statutory intervention is significantly more robust than earlier administrative efforts, such as this 2021 notification from the National Council for Teacher Education. The NCTE attempted to help by making TET certificates valid for life, but that did nothing for the thousands of veteran teachers who were never required to take the test in the first place. To maintain the objective of improving education, Section 23(7) of the bill mandates structured professional training and capacity building for these veteran teachers. Critically, Section 23(7) delinks this training from job security. Teachers are encouraged to upgrade their skills, but their employment is no longer contingent on passing a modern exam. By removing these punitive measures, the bill replaces a system based on the threat of termination with a framework focused on professional development. This entire crisis stems from a conflict between two valid constitutional objectives. On one side is the Supreme Court's mandate to enforce Article 21A, ensuring that every child receives a high-quality education from qualified teachers. On the other side is the principle of natural justice, which protects established workers from being penalized for failing to meet requirements that were not part of their original terms of employment. Enforcing the quality mandate retroactively created a conflict between new standards and existing service rights, risking hundreds of thousands of veteran careers. The 2026 Amendment Bill acts as a counterweight, restoring balance by ensuring educational reforms are implemented with fairness and proportionality. Parliament's intervention does not abandon the pursuit of higher educational standards. It ensures those standards are applied prospectively to new hires, rather than retroactively to veterans. This scenario serves as a case study in the system of checks and balances, demonstrating that when a judicial interpretation creates an immediate risk to workforce stability, legislative policy must intervene to protect established rights.